I'm in Ottawa, in Canada, located on the unceded territory of the Algonquin people. And what I was thinking about addressing in my comments is a lot of my work has been on copyright history. So I wanted to kind of put this discussion a little bit in the historical context to talk about why knowing about copyright history is important. Then to talk a bit about copyright and access to scientific works. And then third, to kind of come to that question, is human rights talk valuable, or what does it bring to the discussion? Each just very briefly. Talking about copyright history, the reason I find that history to be so very important and so interesting as well is because it provides so much insight into, first of all, the possible, but also the impossible, or the limits of some of the initiatives that have been undertaken or that we're discussing. The history of copyright is just chock full of these alternative visions and formulations and moments where copyright looked very different. For example, who would realize today that when the Berne Convention was founded, scientific journal articles were placed functionally in the public domain, but they were at the founding of the Berne Convention. And I think this does two things. It causes us to question the idea of progress that's often associated with the history of copyright or intellectual property or in general. But second of all, it just brings to mind that possibility and what was different about that moment that allowed that to be possible versus today. The second thing that copyright history teaches us about is the impossible. First of all, the moments where what seemed impossible was achieved, but also accounting for some of the failures as well, when huge things were achieved for user rights. Several of the major international battles and initiatives for user rights that have been fought by country coalitions and civil society coalitions, and that have been won impressively at those moments, have also resulted in very little in terms of concrete actual access or changing the direction of what is overall an expansion of intellectual property rights over time. So I think what that teaches us is that future initiatives or current initiatives have to do better, have to think bigger, and have to really take on board and understand why so many huge international past initiatives have failed. My book, the International Copyright and Access to Knowledge, looks at the international copyright system, focusing on those fights for user rights. And I think that's important because one of the things that we can ask in looking at that history is anything different or better today? And one of the chapters in that book gives a history of international copyright in scientific works, and it's looking mainly at the Berne Convention, which is still like the beating heart of the international copyright system today, containing the core principles of it, and which, as was noted by one of the speakers earlier, really stands in the way of many of the progressive visions that we're talking about right now. And the key takeaways of this history of copyright in scientific knowledge or scientific works are that scientific works were not always treated the same as other copyright works. From the founding of the Berne Convention in the 1880s, there was a real recognition that scientific works and activities were different, that there was a special public interest in access to those, especially at a moment when vaccines were just being discovered and developed for the first time. That moment, in that moment when the Berne Convention was founded, it wasn't founded in a human rights law context, and yet the need for that dissemination was recognized as different from what it was for other works. The other takeaway from this chapter is that the rights that were established for access to scientific works, which were initially much broader, once were quickly narrowed and slipped away. And over the years, the massive country coalitions, civil society efforts that were put into establishing default public domain access, exceptions, compulsory licensing provisions, protocols, appendices, development agendas, are all and have been massive, astounding accomplishments in their own right, but have often culminated in something that was basically ineffectual. And I think that a lot of these things happened and in a way failed because they took place in the context of a regime that was essentially and is a colonial system, in the context of a political economic system and an international institution that is not a fertile ground for these progressive initiatives. I mean, France had multiple votes for decades in the history of the negotiation of the Berne Convention because it voted on behalf of Tunisia and Morocco and other countries at various points. And I think there's a greater reckoning that needs to be had with that history and the way it still shapes the present of intellectual property today, if many of these progressive changes that we're talking about are to go anywhere. And that brings me to the last question that I wanted to touch on, which is, does human rights language in this regime make a difference? As you know, WIPO, which houses the Berne Convention and the WIPO treaties, is a UN special agency, and for many decades operated largely with disregard to its position as a UN agency and with not a lot of regard to human rights concepts. More recently, since the establishment of the development agenda, it was brought to reckon with its position as a UN agency, and there have been many initiatives that draw on human rights principles, such as the reports of the special rapporteurs, the document provided for the class today, the development agenda, the sustainable development agenda. And the question then is, has this reference to human rights made a difference? And to that question, I would answer first yes and then no. On the yes side, I think that approaches like the ones being suggested today and that have been suggested as a part of the development agenda, those calls to reckon with human rights, do lay and establish some kind of fertile ground, or whatever fertile ground is possible in the context of those international institutions and maybe even more at a regional or local level. But on the other hand, I think the answer is no, because in many cases, what I think is happening is that WIPO's references to human rights often legitimate and strengthen WIPO or the WTO, which are working largely to extend intellectual property owner rights, and they provide a veneer or a fig leaf, a checkbox, or something to say in response to human rights critiques in a system that in the big picture is watering down a lot of the approaches that we would like to see established, that in the big picture is keeping scientific data and works out of the hands of the people of the world, that and that continues the kinds of inequities that may only grow in the context of big data and data colonialism.